I'm going to talk briefly on holiday entitlement during furlough, as well as issues to consider when staff return to the workplace and carrying out fair redundancy processes. Now, we do only have time for a very brief whistle-stop tour of each of these subjects today. So for that reason, please don't rely on anything I say today as giving you legal advice. If you need specific legal advice on a situation that's arisen in your place, then in your workplace rather, then please contact me. My contact details are at the end of this presentation. So with that in mind, let's start with looking at holiday entitlement and furlough. Now, it is established that employees continue to accrue holiday during any period of furlough. Okay, they still accrue holiday in the usual way. But what about taking holiday during furlough? Can employees take it? Yes, they can, is the brief answer. Any holiday that they've already booked should be taken as normal. If they want to request holiday, then you can agree to that or not agree to that in the usual way. Now, slightly more complex is the question of whether you as an employer can oblige your staff to take holiday while they are on furlough leave. We had some guidance produced on the 13th of May from the government, but it is just guidance, it's not law, it's not binding. But the guidance started off by saying that employers can, if they give the right notice period to staff, oblige those staff members to take holiday even though they are furloughed. However, the guidance went on to say this, and I'll read this. If an employer requires a worker to take holiday while on furlough, the employer should consider whether any restrictions that worker is under, such as the need to socially distance or self-isolate, would prevent that worker from resting, relaxing, and enjoying leisure time, which is, of course, the fundamental purpose of holiday. Now, this does muddy the waters slightly because it's established law that the whole purpose of annual leave is that so we can take a break from the work we're meant to be carrying out and rest and relax and enjoy some leisure time. Now, can an employee taking holiday in this current climate enjoy a period of relaxation and leisure? That's up for debate. Employers are going to need to consider their individual workers as well as the current guidance around lockdown. Think about the worker who is vulnerable or extremely vulnerable so that they're shielding, they can't leave the house for 12 weeks. If you oblige them to take annual leave, are they able to enjoy a period of rest and relaxation? And we might see some claims coming out of that area once lockdown has ended, if employers are obliging people to take holiday during furlough. Now, when it comes to paying employees when they're on holiday, even if you are paying 80% at the moment, capped at the 2.5 under the job retention scheme, even if that's what you're doing at the moment, I'm afraid that when somebody is on holiday, you need to pay them their normal wage, 100% of their salary. Okay, this is because the guiding principle around holiday pay is that a worker on holiday should receive what they would receive if they were at work and working. So that means the 100%, their full normal pay. Of course, you can claim 80% of that back from the job retention scheme. So there's a benefit to you in obliging employees to take holiday during this time, but remember to give them the correct notice period. Lastly, on this subject is the question of whether holiday can be carried forward. A lot of employment contracts will say you need to use your holiday, employees need to use their holiday in the year in which it accrues. However, as part of the emergency package of legislation that the government brought in at the beginning of this crisis, there was regulations which said if it is not reasonably practicable because of COVID-19 to take holiday in the year that it accrues, an employee is entitled to carry forward 4 weeks of it, so not all of it, 4 weeks of it, into the next 2 holiday years. So effectively you can kick the can down the road a little bit on that if you need bums on seats once this crisis is over. Right, moving on to our next topic then, that's the question of issues that you need to be considering as employers when staff return to the workplace. Now, of course, different businesses are going to face different challenges, but what is the same for any employer, whatever their size or industry sector, is that you need to prioritise a safe system of work. It is down to you as employers to provide a safe system of work, and how do you do that? Well, you start with a risk assessment, frankly. You start with a risk assessment, and then you follow that risk assessment, and you do all that you reasonably can to set up and maintain a safe place of work. Now, there is government guidance on what you should be doing, but the obligation rests with you. It's just guidance, it's not law. Okay, so carry out your risk assessment first of all. Tailor that to your workplace and to the dangers of coronavirus, paying particular attention to different groups of people who might be adversely or more severely affected by the risks involved. Now, share your risk assessment, absolutely share your risk assessment with your staff. Invite them to comment on it, correct it, add to it, amend it, and take any comments they do make very seriously. Once you've carried out your risk assessment, you use that as the basis to implement your safe system of work. So ideally, you're going to eliminate the risks where you can. Eliminate any risks of infection where you can. If you can't eliminate risk, then you put in measures to reduce the risk down to its very lowest possibility. And the Health and Safety Executive has some guidance that might assist you when you're carrying out your risk assessments. Then, of course, implement your system and review your system regularly to make sure it remains fit for purpose. For example, there's no point in your risk assessment saying, right, we'll put signs up all over the place about everybody washing their hands. There's no point doing that unless you're going to provide adequate facilities for people to wash their hands. Soap, drying facilities to avoid cross-contamination. The other things you need to think about, and this is by no means an exhaustive list, but think about health surveillance. Who's going to keep an eye on staff to make sure that we spot people who become symptomatic? Make staff and visitors aware of what they should and shouldn't be doing. For example, no hot desking. Make sure the workplace and equipment are cleaned, deep cleaned daily by a reputable firm using reputable cleaning products. Think about ventilating the workplace if you can open windows. Of course, you need to make space in the office so that people can socially distance. And that's not just between desks, that's when people are going out for lunch, going to the toilet, using the kitchen to make a cup of tea. I've already mentioned hand washing facilities, that's pretty obvious. And lastly, and this is the last thing you should consider, is do you need to provide PPE? Now, if you're providing protective equipment, you're opening up a whole other kettle of fish. Does it fit? Is it adequate? Do staff know how to use of it and dispose of it safely? So protective equipment is a last resort, really. You shouldn't just be providing it in the hopes that that will tick the box. Okay, it's an absolute last resort. Now, what do you do for employees who are classed as vulnerable or extremely vulnerable? Because there are a lot of people in that group, as we know. Now, you need to engage with these people as individuals. Anybody who has a medical condition that classes them as vulnerable or extremely vulnerable will probably be disabled as defined by the Equality Act, which gives you an extra layer of obligation to them, an obligation to make reasonable adjustments. Now, you need to ensure that they are consulted as individuals so that you don't miss any of your obligations and end up with a discrimination claim. Now, you might have employees who refuse to come to work, either because they're vulnerable, extremely vulnerable, or because they just don't fancy it, they're nervous, maybe they're shielding someone at home, maybe they don't want to get the bus. So what do you do with that group? Well, you need to engage with them, really. You need to find out what their concerns are, and you need to assess objectively whether those concerns are reasonable. And someone who is shielding a family member will be in a different category to somebody who is nervous and just doesn't want to get the bus in. Okay, so the considerations for each person are going to be different. Don't just trot off down the disciplinary route if someone refuses to come to work, because you need to understand that if an employee reasonably believes there is a danger in the workplace, a danger that is serious and imminent, they are legally entitled to refuse to come to work. And it's about the employee's perception of what is reasonable. Okay, it's not down to us to say, well, that's not a reasonable perception, there's no risk here. What the tribunal will be looking at is the employee's perception of what is reasonable. So that is why you need to engage with them. Anybody who has triggered that right and says that they believe there is this reasonable risk is protected from dismissal and detriment. So engage with them carefully, hear what they have to say. If you have a trade union, get them involved. If you've got an occupational health advisor, get them involved as well. And in that circumstance, I would definitely suggest that you seek legal advice around the particular concerns that your employee might have. Now, employees who have childcare responsibilities, they might be happy to come in, but the schools aren't open for their children, or they don't want to send their children to school. Now, employees have employees with children and childcare responsibilities have standalone rights as to time off. There is time off where the normal childcare arrangement fails, and there is also parental leave that an employee with childcare responsibilities can take. You're meant to give 21 days notice of a request for parental leave as an employee, but I would suggest that you be flexible. Parental leave is unpaid, so you would have to explain that to your employee. Maybe think about inviting them to use up some of their holiday, linked into what we said earlier. Again, consult with people individually. Don't immediately say to somebody that they must come to work. It's important that we consider people as individuals, which I know is a burden when you want to get your business up and running, but that's the way to avoid tribunal claims. Lastly, then, and I know this is a whistle-stop tour, it's all we've got time for, but my contact details will follow, as I said. I just want to touch on redundancy dismissals and how to avoid an unfair redundancy dismissal, because we all know that, unfortunately, redundancies will be on the cards. Even Boris Johnson acknowledged this in his discussions yesterday. Now, the important thing to remember with a redundancy dismissal claim is that size matters. If you're looking at 20 or more staff, then you have an extra layer of consultation that you need to carry out. I'm not going to talk about that today. I'm just talking about redundancies that affect less than 20 people. Okay, now with that in mind, what does redundancy mean? Well, redundancy means that your need for employees to carry out work of a particular kind has ceased or diminished. We have 10 secretaries, we only need 5. Therefore, our need for secretaries has ceased or diminished. If you find yourself in a redundancy situation, the first thing you need to do is pool those affected employees. You put them in a group, okay? Do not forget to include those employees who carry out work of a similar kind. That's very important, and failure to do that can lead to an unfair dismissal claim. Once you've got everybody in your pool of potentially redundant employees, you can start consulting with them. You have a group meeting where you explain why the redundancy situation has arisen, and you explain the criteria that you will use to decide who in the pool will be selected for redundancy and who will stay. You can invite applications for voluntary redundancy at this stage as well. Once you've decided on your criteria, which must be objective, you can then apply the criteria to those in the pool. You have one-on-one meetings with everybody in the pool. They are entitled to be accompanied at these meetings by a workplace colleague or trade union representative. At the one-on-one meetings, you can discuss the criteria that you're using. You should give the criteria to the staff in advance, ideally. You can discuss your scores on the criteria and how they would score themselves. And it is also imperative that you look at alternative employment within the company and within any associated company if you're part of a group. A failure to consider alternative employment for those who have been made redundant will render you on the end of an unfair dismissal claim. So be sure to look at alternatives. Please bear in mind there are extra rules for those who are pregnant when this process is ongoing, when a redundancy process is ongoing. So I do appreciate that's absolutely a whistle-stop tour, but you can see my contact details on screen now. If you have any questions, feel free to put them in the chat. I can either answer them now or at the end of everybody else's session. Like I say, if you need specific legal advice, please do get in touch. Thank you very much. Back to you, Simon.
Thanks, Sam. Thanks very much. If anyone does have any questions that come up after this, then please do get in touch with Sam. There's some a lot of information out there that perhaps we haven't covered. So I'm just going to see if we've got no immediate questions there, but just to see if there's any general questions that you've been asked, Sam, on this subject. I'm just going to have a look. over here. Bear me a sec. So the sort of questions I think you've possibly been asked in the past is what is the notice that employers have to give employees to take holiday?
Yes, this hasn't changed with coronavirus or furlough or anything. It's always been the case that as an employer, you can oblige your staff to take holiday, providing you give them twice the notice of the holiday you want them to take. So if you want them to take a week off as annual leave, you need to give them 2 weeks notice.
Okay. And with redundancy, what does work of a similar kind actually mean?
Okay, yeah. So you want to be careful that your pool it contains everybody who carries out a similar kind of work. Meaning, if I was an employment and family lawyer, and there was a redundancy situation affecting the family law team, we would need to consider whether it would be appropriate to put me in the pool because I do work of a similar kind to the family lawyers. I mean, I don't know the first thing about family law, but if it's to do with bumping is what it's called. So if one person can bump someone else out of the role, we need to make sure that we've included all those in the pool that are potentially affected by the redundancy to avoid it being unfair.
Okay, and the question's just come in. Can you make staff redundant whilst hiring at the same time?
Well, it depends on the roles. I wouldn't recommend it though, because this is where the alternative employment comes in. If you know redundancies are on the card, I would suggest that you stop recruiting, because if you have person A who can fulfill the role you're recruiting for, then as part of a fair redundancy process, you should offer person A that role that you're recruiting for as an alternative to redundancy. If the roles are massively different and person A couldn't do that role if their life depended on it, then the situation is different. Of course, you don't have to promote people or put people in a position that they can't fulfill. That's just setting them up to fail.
Okay.
But you need to be very careful if you're recruiting at the same time as carrying out a redundancy process, because person A may have some skills that you don't know about, or they may be willing to retrain if the role is only slightly different.
Okay.
And those are all the things that an employer needs to consider before they decide who goes and who stays.
Okay, there was a thank you very much for that, Sam. And
You're
there's
welcome.
one here. Can an organisation say that none of their head office employees can work from home after the pandemic is over?
It's going to be quite difficult to say that, because if people have worked from home effectively during the pandemic, what business reason do we have for saying now, no, you can't? If you have a genuine, objective business reason, then you could talk about getting people back in. I wouldn't go in with your big size 9s right now saying don't do it. You also need to think about somebody who is disabled. Like I said earlier, you have a duty to make reasonable adjustments for disabled people, and one of those might be to continue to allow home working. I always caution against having one rule for everybody, because you can trip yourself up into a discrimination claim in that case. If perhaps somebody was underperforming and you felt that that was because they were working from home, you would have an objective reason for insisting they come back in the workplace. But it is very rare in employment law that one size fits all. So I would caution against doing that, yeah.
And one final thing, with regards to risk assessments, are there any available templates out there that you know of?
Oh, there aren't really, and I would caution against using a template for a risk assessment, because the whole point of a risk assessment is that it's personalised to your workplace. The health and safety executive have a form where, well, I was going to say it's a template. It gives you some guidance as to how to carry out a risk assessment, and it will give you a form where you fill in the blanks. So it's always worth having a look at the health and safety executive's website. But the risks to your business, to your office, are going to be different to the risks to someone else's office, somebody's factory, somebody's shop. So try and steer clear of templates when it comes to risk assessments.
Right. Thanks, Sam. Thanks very much.